everybody. We're going to take up zoning text amendment 1811, telecommunications towers, approval standards. I want to thank everybody for all their commentary. People have been working the midnight oil and raising their concerns, and we had a good and robust public hearing. So that's what this is all about. I do think that some factual issues or some information that needs to be clearer as to what's proposed and what the actual process is. So we're not going to, I don't think, I'd be surprised if we actually vote anything today. We'll see how that goes. But I would like to staff and the county executive people to go over exactly what's proposed in this legislation. I think there's a little bit of confusion about the process, particularly with respect to the neighborhood issues. So Mr. Zients, Ms. Nurmi, Ms. Herrera, Ms. Swartz-Jones, whoever would like to come and join us on this subject and tell us, for the record, let's make very clear how this is proposed to work.
Okay.
And well, let Mr. Zients take the first step.
And just like I correct my dog, I could be corrected if I get something in error. There's enough people here to do
I see that you have the requisite number of footnotes. There's not the usual humor involved, but
I didn't have time.
you didn't have time for fun. Okay.
It was I had a full day and a half between the public hearing.
Well, that and that's the other thing. We appreciate that this is on a pretty compressed time schedule. Our challenge on the council is whatever we do with respect to land use, we have to do it this month, in the month of October. So that's why we're diving right into these interesting issues.
Right. Yeah. The council.
Because of the law with respect to the turnover and I think it's a charter restriction with respect to how we can handle these sorts of zoning issues.
Matter of state law.
State law, okay. So there you go.
Okay.
So that's why.
So this ZTA would generally allow telecommunication facilities more liberally than the current code. It would do this in two types of steps. It would treat poles that are larger than 22 feet, which are typically along, you're taller, I thought I said taller, which are along major roads, which are generally the larger Cobra headlights, the things that look like a Cobra kind of thing. Yeah, and for those uses, it would be a permitted use. There are some, it would have to be at least 30 feet from a house, and it would be generally permissive that way. You could not then reduce that amount to get a conditional use off of that. Either you're allowed or you're not at the 30 feet. Then
so just for that particular point of reference, so the ones that I think are on Trevilla Road, they are on poles pretty high up on a relatively busy road. Is that the kind of experience that we're talking about?
That's correct, and it would also include the wooden utility poles would be treated the same way. So if you're putting it on top of a pole, that's a pole that could withstand the weight of these antennas. It may or may not. It will generally need to be replaced for height. Because they have to stand clear of what's going on the pole to begin with. But the wooden pole is there. Those tend to be 6 to 8 inches in diameter. They're substantial already. So because that is a lesser change than would occur on the shorter poles, they're given greater permissions.
So the point is, the ones that would be permitted, basically, are the ones on existing poles and they would be at over your 22-foot height level. And but those poles already exist. They might need to be replaced, but visually, they're within the existing landscape already, correct?
Right.
And they would have to be 30 feet from any house,
That's correct.
under any circumstances.
Right, and then, of course, you have the Cobra lights, which would need to be replaced a lot, because that's a stanchion that could not
Sure.
withstand that weight.
So the kinds of poles that have streetlights on them,
High street lights.
high streetlights are the kind of poles we're talking about. So if everyone can visualize where those are. Presumably, there's some around here. Do we have one of these out there? Yeah,
You
okay,
can look right outside.
yeah, sure.
But on that point, do we anticipate that, for the most part, we're going to be replacing existing poles where they exist with new structures? Isn't that the case?
Yeah, so Mitzi Herrera, Department of Technology Services, yes,
Right.
the ZTA is structured around, there is an existing streetlight, utility pole, or site plan approved parking lot light now. And the idea is that I want to replace it with a structure that is stronger to
structure.
support the antenna.
Right, so it isn't entirely helpful to visualize an existing structure. It's going to be a new structure with a new apparatus on it.
So,
but
yes,
it's
however,
replacing
the
one.
utility pole
looks different.
will be replaced with
Something that looks different. It's a different structure.
well, it would be replaced with a wooden utility pole. Chances are that it's taller, it might be slightly wider at the diameter, depending on what safety requirements PEPCO requires. We are working on designs to share with the public right now in terms of, DOT has about 6 different types of streetlight designs. So the idea is that if you're replacing one of those poles, here should be the design for what the new thing will look like. And we're in the process of having a design meeting on that this month.
Yes. I know that the chair wants to hear from all of you about what is before us and how it will work, and I'm happy to do that. Just while it's on my mind, and I don't need a response to this right now, just make a note. One of the big issues that I think is really valid about what you've just described, which residents have raised, is that there is a complete lack of confidence that the old poles will be
Okay,
removed.
let's get to
So
that at a separate point. We're just talking about what's proposed in the legislation.
I'm just putting that marker down for future
Yeah,
discussion.
we got that in the list, okay.
Okay, and after we get, obviously, if we just talked about poles that are 22 feet or taller, we have to talk about 22 feet or shorter.
Okay.
And those typically are streetlights with the luminary directly on top of the pole. They tend to be in residential areas, and it would be used in this manner only where there are not wooden poles at all. So these shorter poles deal with areas where the county has required undergrounding utilities. And in this instance, all of those poles would be required to have a conditional use process. They would required to be, now I forgot the numbers that are in there, at least 30 feet from a house, but the hearing examiner could approve a reduction down to 10 feet if effectively, if doing otherwise would deny service to the area. That is, they couldn't service it from some other facility. The conditional use is modified by this ZTA to be those things that are essential to the pole. How does it fit into the community? Does it work in that community?
Remind us what the standards would be that would be applied to that review.
The standards are particularly written out. It's on page 9, if you don't want to go to the text. The hearing examiner may require the tower to be less visually obtrusive by the use of screen, color, or other visual mitigation options after considering within 400 feet of the character of the residential properties, proximity to the nearby residential properties, the existing tree coverage, vegetation, and design presence of streetlights, utility, or parking lot poles.
So it says it has to meet the requirement of section 3.5, point 2, point C, point 2, point D.
And
What's
they-
that?
Essentially, those are the setbacks and location requirements.
Okay.
One of the things the ZTA is trying to do is not create new, additional poles in the right-of-way. So in all cases, requires you to replace an existing pole near its existing location. And it has, I think it's 2 foot within the existing location as a way to keep it from being perceived as something completely new. Yes, this would be a little taller and thicker than the existing pole. It would have an equipment box that could be a maximum of 20 cubic feet. There are specs for the antenna itself. There's certainly a lot of commentary on the size of the equipment box. This relates to the county's preference for co-locating antennas. With an equipment box of 20 cubic feet, you can locate and have the equipment for 3 antennas at all locations. If you allowed a bigger box and a bigger antenna shroud, you could possibly accommodate 4, and there are 4 carriers. But you never know how those things work out, and this size compromise seemed rational for going forward. If you did not allow the equipment box to be this large, you would have to allow more antennas within the area, because again, the county will push everybody to co-locate as long as you can physically do that. If you didn't have the equipment box big enough, you could not co-locate. So that's what there was that sign compromise. I think that is the essence of what the ZTA does.
Okay, so it has to be located in the public right-of-way?
No, it does not.
No?
This allows it in the public right-of-way. You could still be on a commercial building. You can't be on a single-family residential building under the current code.
Well, what about homeowners association land? Public streets versus private streets?
Certainly, it could be on a private parking lot or a private pole.
So many of our communities where utilities have been underground, this just occurred to me. Many of our communities are HOA-type communities. They have restrictive rules and special designs and so forth and so on. Would they have to concur on the location of these, or replacement of their light standards
Yeah.
on HOA property?
Yes, we're not taking anybody's property in this ZTA. It's an allowance under zoning. It specifically allows for those associations to allow this on a site plan approved pole.
So that is something that if it's on homeowners association property, the homeowners association would have to agree.
Yes,
And if, so it was a private street, same issue,
same issue.
right?
As long as that street light was approved by site plan.
Was subject to site plan. And so that might be another regulatory issue for those particular locations, if there's a site plan that it's subject to. How does that work?
Can I ask just
Well,
same
ju-
question? So you're saying like in Leisure World, like in Montgomery Village, pretty much any deployment inside the boundaries is gonna have to be agreed to
Yes,
by the,
Yeah, it would depend on who owns the land.
exactly.
So that's an important thing to be, right? So that's an important thing to be aware of. It's only where there is, well, wherever, but if it's public, that's why I asked about the public right-of-way. In older communities, their streets, well, I don't know, since the mid-'80s, I'd say most of them are public or private in those HOA-type communities.
I mean, there are some private streets. It's a more recent phenomenon, mainly because private streets mean you have private maintenance, so people have wanted to dedicate. There are those large areas like Leisure World, where they did
They're
not
all
dedicate.
private, yeah.
But, you know,
Village has public streets, actually, right?
Montgomery Village has mostly public streets.
But not
I
all.
assume there are some HOAs that own their parking lots and others.
Internal, parking might be.
Right.
So
Yeah.
that would be another thing that would have to be validated. I mean, the permission of the property owner.
Yes, so and the current process requires that you must show that you have the permission of the property owner to attach an antenna
Okay.
to that piece of property.
Okay. And so ultimately, for these particular polls, which I think is the largest source of community concern, the standard before the hearing examiner would be compatibility. Is that correct?
Yes, it's what I just read. And you would have all of the notice provisions for a conditional use.
So that would be adjoining and confronting property owners and the community association?
Yes.
Okay. Okay. So those are the distinctions. Below 22 feet, most of the residentially based community issues, they would go through a conditional use process with notice to the community and a compatibility standard that had to be satisfied for that to go forward. As I understand it, the hearing examiner would make that decision,
That's correct.
and then it goes where? To the Tower Committee?
Well, one of the things in order to save time in our own processing is the ZTA would not allow it to go to the Board of Appeals, but it would be a direct challenge to the,
So the hearing examiner would make the final decision.
up
And
until
then,
it goes to court.
and then if you wanted to challenge that, you'd go to circuit court.
Yes.
Okay. Otherwise, you could go to the Board of Appeals, and then you go to circuit court.
That's correct.
Yes,
So
but-
that actually facilitates the resolution of that. to a certain degree.
It does, but, you know, Board of Appeals is a process where somebody could stand up themselves without an attorney and say, hey, the hearing examiner did something wrong, and they could correct that.
Yeah.
So it is, it's a good relief valve if you have the time for it. We suspect that we may not have the time.
Okay, so now we have two other issues. Mr. Leventhal has raised the enforcement issue, which I heard a lot about that. And also, the other issue that I'm interested in is the fee issue. What is the revenue that's being generated from this? How are we charging these utilities? And how are we really getting value back to the community for this burden that's being created? Of course, the utility company, the companies all say, well, we're providing the ability to download more videos and whatnot, but the real issue is the resources that are being returned to the county. So two issues. We heard a lot about this. What's the deal with the stuff that's already out there that doesn't get removed? I know that there's a story that the PEPCO people come up with, but it's annoying to communities. So there's the enforcement issue. And also, are they really meeting the standards that they claim they're going to meet when they put this stuff up? We've heard from community members who feel that what's been indicated on an application is not actually what's constructed. I believe that's part of the issue you were alluding to there, right, Mr. Leventhal?
May I comment?
Sure.
Yeah, thanks. Yeah, you stated it very well, and I think that there is, regardless of what you think is the urgency of installing 5G or the harm that these things might do aesthetically or for health reasons or whatever else, I absolutely think there is valid reason not to trust that old poles will be removed And I do think that there is valid reason to question whether DPS will actually inspect every single one of these things and say, yeah, it really is 30, it's not 27. I think those, based on past performance and fielding constituent complaints over many years and Pepco's unwillingness to deal with the mess it leaves behind when it cuts down trees and stumps and all of these things, I think there's, it rings true to me that there wouldn't be removal of old poles, that you'd get into a finger-pointing contest. Well, we didn't erect the pole, it's not our pole, I don't know whose pole it is was erected back before World War II, nobody can figure it out, so the pole just stays there. Whereas I wonder whether we might look at some language that compels the wireless companies, if they're getting the benefit of installing the new structure, to remove any old structures, put it on them, and get past the he said, she said, you got telephone cables, you got power cables, you got all these things on the pole, we don't know whose pole it is, not our problem, let someone else deal with it, nobody deals with it, the pole stays there. That seems to me a very, very valid concern, and that's the first concern. And the second concern, as the chair correctly articulated, is just because we're saying it's going to be a 30-foot setback or a 60-foot setback, it might not be, and who's ever going to go out and police it?
Okay, so the county executive has heard the concerns when we went through the last zoning text amendment for commercial areas. In that particular zoning text amendment, we did address the removing the double poles. What we've done since then, and I'll let DPS explain what they've done, and I'll let Mitzi explain the fee issue when we get to that. But we did put a process in place. We thought it might require regs, but it does not. DPS has already put a process in place, and I'll let Diane explain what that is. So that's already in place for enforcement, so that when somebody says that they're going to do something in the Tower Committee report, then DPS will be going out to enforce that.
Despite my encyclopedic memory of every line of every zoning text amendment I've ever voted for, could you refresh my memory on what we did in the commercial areas regarding removing the old poles?
Basically, what we said is the old poles had to be removed within 180 days.
Removed by whom?
It will have to be removed by the utility.
Why don't we put the onus on, isn't the wireless transmission company going to install the new device?
What happens is,
Why wouldn't put the onus on them? They're getting the benefit. Why would a utility bear the burden of paying for an improvement which they don't benefit from? Only the wireless companies benefit from it.
So depending on the specific situation, there may be times in which the utility company comes in and it does the work, and then it bills the wireless company for the work, but their preference is that it's the Pepco contractor or the Pepco.
Pepco wants to remove its own poles.
Right,
And then they bill the wireless company.
yes. In some cases, now some cases they may have something where they, for whatever reason, they've said, yes, you can go ahead and do the work. The FCC actually just released an order in which what they were looking at is the ability for a new attacher to come and just say, I'm going to do all the work at the same time, which people call one-touch make-ready, and I will do the work for you using an approved list of contractors.
Okay.
That order just came out a couple weeks ago, and it has not yet taken effect, but it should probably within the next 2 months.
So tell me again, please, I'm still not clear. What, I believe it was ZT 1802 that dealt with the commercial areas. What did that do? Is there language in there that compels something? What is it?
Yes. So the language in there
I think
states that,
180 days to remove.
so it's in your packet on page 6, circle 6, line 61 to 65.
Okay.
So what that is saying is that the pre-existing street light or the parking lot light must be removed in 10 days after the power is activated to the replacement pole. And if it is a utility pole, we're talking like the wooden utility poles, it's 180 days. The reason for that is that there are attachments. Most commonly, they are Verizon attachments on the existing pole that need to get moved off. And what we're trying to determine is, in the new FCC order, is there an ability for the new wireless company to come in and move that equipment if it hasn't been moved in a certain period of time, and they can simply send the bill to Verizon? Pepco's concern is that I'll send the person the bill and they just won't pay it.
Right.
So what we're looking at is that the FCC, in the order, created a bunch of enforcement sections, and one of the things that they should enforce is if I can send the bill, then they have to pay the bill.
Okay, but I have always been under the impression that the county council, acting as the district council, can't legislate anything for Pepco.
Well,
We
there-
can't make Pepco do a darn thing. They're subject to regulation by the Public Service Commission, not by us. So to say that a pole must be removed, yeah, sure, I mean, I must have a wonderful breakfast, but it doesn't matter whether you pass legislation if we don't have the authority to enforce it. So what? We can't do that to Pepco. We can't make them do a thing.
The ultimate resolution to double poles and having forced removal is the Maryland Public Utilities Commission. They have the authority over.
Public Service
Pepco-
Commission.
Public Service, I'm sorry. They have the authority over these poles.
And so the neighborhood's concerns sound pretty valid to me.
So, okay,
Because the Public
so-
Service Commission, we can't compel them to do anything. This language, it seems to me, am I wrong? A pre-existing street light or parking lot light pole must be removed, et cetera, et cetera. I don't see how that has any force or effect.
We would issue a citation.
Can we cite Pepco? Do we have that authority?
Well, we would issue notice of violation, and we would follow up with citation and abatement orders. I think that ultimately the outcome of it would be determined in court, because in theory, if the pole is no longer used, then would it still fall within the Public Service Commission's authority? I think it's, I would say that is questionable.
Yeah,
And
this is a real problem.
To answer the first part of your question, with zoning text amendment 1802 and with the pending one in front of you, we've actually made automated, but we are automated, but we've made changes to our automated processes. We're requiring certain elements of information within the online application. And at the time a permit is being issued, we are preloading, for a replacement pole, we are preloading a final inspection. This is actually what we do now. It didn't used to be that final inspections were required for houses, for building permits for houses. We now require it, we preload it. We're going to be doing the same thing with replacement poles, so that we will have an inspector out there to see whether or not the replacement pole has actually, the old pole has been removed. If not, we will use the tools that we have until we are told by, and the tools that the council has seen fit to include in the zoning text amendments, until the court tells us that that's not appropriate, so.
So I'm going to ask the question again. And this gets to a larger issue. Telecommunications companies are not regulated by the Public Service Commission. They're not treated as utilities under Maryland state law.
The
Verizon, Fios, Crown Castle, Wireless, all of these companies. The Public Service Commission has jurisdiction, I believe, correct me if I'm wrong, over electricity, natural gas, water.
The Public Service Commission also issues a certificate of convenience and necessity, which is a license to operate a competitive telephone service. So the companies that you're talking about, they do go to the Public Service Commission for authorization. The Public Service Commission, in looking at the double pole issue, there was legislation that was proposed, it was altered. What they are doing right now is that they are receiving information about how many double poles are out there. They voted, I believe, for the next several years to gather that, and there's regular reporting. In the meantime, it's my understanding that Pepco is working with DPS. They have a list of double poles that are out there, and they are working through, they have a monthly report that they have in which they are working to cure the problem going back. And what we looked at is we put the language in here to prevent the problem from happening going forward.
But I don't have confidence that this language has force or effect. So my question is this, because I remember in the past we were dealing with tree bills, and we were told you can't legislate anything for Pepco. You just don't have any authority over Pepco. You can't pass a bill that Pepco must comply with. So again, I would ask the question, do we have the ability to legislate with respect to Crown Castle? Do we have that authority? Can we compel Crown Castle to make sure that the pole is removed? It doesn't matter who removes the pole, as long as what you're describing is Pepco removes the pole through its contractors that it likes to work with, and then Crown Castle pays Pepco. So can we compel that? You're talking about what is a hoped-for agreement later that the law doesn't compel? Can we compel the wireless companies to make sure the pole is removed and to bear the cost?
I think,
Ownership.
Can I just or add to that, and can we say before you, like a term of installing a new pole is agreeing to remove the old pole? You can't because,
so here's the
Well,
thing.
that would be comparable to what I'm
Right, if,
suggesting.
so if we're talking about the streetlights that the county owns, yes. We are the property owner. The condition of using the property is that the other pole has to be removed. The challenge that this has brought to light is that here you have a case in which the pole is owned by Pepco, the utility. The attachments coming in are gonna be owned by somebody like Crown, but the underlying structure remains owned by Pepco. And the new Crown attachments are going on the new pole installed, not on the existing
Okay,
pole.
so, but what the council president just said, I agree with you. You could grant the right to Crown Castle to install this thing in the right-of-way, subject to a contract with a contractor to remove the old pole. Otherwise, you don't get approval for a new pole.
Sure.
Well,
That's with respect to Montgomery County's control. Those are the metal poles, right?
no, the Pepco poles.
No, well, there are two different kinds of poles.
Right. But
There are metal poles and there are wooden poles. Wooden
if-
poles are Pepco poles.
Right, so if you're talking about it from the wooden poles, what you essentially effectively be saying is, attacher, Crown Castle, you want to come in and you want to have limited use. As a condition for the limited use, you must secure a requirement that the old pole is going to be taken out.
Yes.
Now, the part that I will say that is complicated in that is that Maryland right now is subject to the federal pole attachment rules. We did not opt out. So what you have to look at is there's the pole attachment order, and as I just mentioned, this one-touch make-ready order that was just released a couple weeks ago. What you need to see is there authority within that? Because you have the attacher and you have the pole owner. So can the attacher require the pole owner to do something? And if the pole owner doesn't do it, then the attacher, then what we would say is in the attacher, you can't use our
That's it. Right, you don't
poles.
have the contract, you can't get the new pole.
And it's arguable that under the new OTMR, the whole point of it was to give more authority to the attachers to use the contractors that were specified by the utility company. There's an agreed-upon list of contractors that you can use, so
under the new one-touch make-ready.
under the, yeah, which hasn't taken effect yet, but
Why-
arguably, I would say that, yes, you could impose that as a
Okay, why
condition.
don't you put your drafting heads together on something to that effect? And of course, that requires some additional conversation. Let's agree that we're going to control this until we're not going to control it. Okay? So let's do this. If I might interject, this exchange is reminding me, last week, it was Tuesday night, we had everyone here. Wednesday, FCC was going to do something. Did they do it?
Yes.
And what did they do exactly?
They put out 120 pages. You know,
And what did those 120 pages say? Anybody read them?
Get out of our way.
Well, they did actually make some changes that were things that we had lobbied, some they did, some they didn't. The one that's most relevant to your last question is on fees. The FCC took the position that where the federal statute says that you can charge reasonable compensation, that means it is limited to the local government's costs. We don't think that that's the case, and there's some other legal situations, and when Congress passed a statute in which they said using federal property, they said fair market value. So that's the most important piece of it. The other piece of it is that they suggested shortening the shot clocks. So for right now, if you co-locate on a structure, it's 90 days to take action, and if it's a new structure, it's 150 days. What they want to suggest is that if you're talking about equipment that's 28 cubic feet and a pole that's 50 feet or shorter, those shot clocks should be reduced to it's 60 days if you're attaching to an existing structure and 90 days if it's a new one.
Suggesting? You're using the term suggesting.
Oh, I'm sorry, well, okay, so what the FCC initially had proposed or had floated an idea of what people have called a deemed granted approach, which is a preemptive, where if you didn't comply within that shot clock, it would be that you give an approval. They backed off from that approach, and what they've said is, we think that this is the reasonable standard. If you don't act within that period of time, the wireless carrier can go to court and to try to compel action and use as an argument that the expert agency has stated that it is unreasonable to take longer than this period of time, and I assume that would be a fact.
It's not a regulatory requirement. It's just as you say, a standard that they would recommend be applied. Apparently,
Yes.
they did not preempt us.
Not fully.
No, but they've essentially created a rebuttable presumption.
Okay, but it's a legal argument that could be made,
Yes.
but not an inviolable standard.
Correct, and I think our.
Well, that's good.
But I think our position also would be is that in addition to challenging it as part of a
Well-
joint coalition now, is that you'd have an as-applied standard in which you would say this is a reasonable process.
Well, that's why we have a whole legal profession to argue about that stuff. But at the end of the day, so we're not preempted, and the one thing that's of concern to us, real concern, is our ability to be compensated for the use of the public right-of-way.
I would say there's one more concern in this order, and that's its actions on what is denial of service. We're in the Fourth Circuit. We had case law that said a gap in service is a denial of service, but if you are augmenting service, that's not a denial of service. Makes a big
So
difference.
did they change the standards?
They did.
So is that effective, or is that just out for public comment?
That would take effect. The FCC, because they issued 4 different orders, basically what's gonna happen is there's an appeal process that's gonna, time window that's gonna open up to challenge it. You would go to court to ask for a stay. If you aren't granted the stay, it's effectively 90 days from publication in the Federal Register, so roughly, 90 days plus a couple weeks.
In 3 months, it will take effect unless it's been challenged.
And we may challenge it.
We are planning to challenge it.
So we're going to challenge it, so it won't take effect in 90 days.
That is the hope, that you can get a court to issue a stay order. Because it upends a lot of things, and there's a particular legal
Multiple
standard.
elements. Okay.
Yeah.
So people are going to keep arguing about that for a while.
Yes.
That much we know for a fact. Okay.
And the FCC has more on their agenda for all of these codes and issues. They're not by any means done with their potential issuance of new orders.
Yeah, I mean,
Well, let's
that's-
not predict what the feds are going to do these days.
Oh, they've released some other ones that they'll be out there. I mean, their whole goal is that we should give away public property for free. We should let industry build wherever they want, and that's the end of the story. No obligations for build out. No obligations to have job training or support local jobs. It's a very one-sided, they have a very favorable administration and chairman in which the obligations are one-sided. And in fact, the Montgomery County resident, Blair Levin, who is the author of the National Broadband Plan, has come out on several occasions and said, this is a totally one-sided process in which it would make sense if you said, I'll give away things because you have to build everywhere. But if you simply say, you get everything and you have no obligations, that does not mean that suddenly when I have more money in my pocket, I'm going to take care of those obligations.
Okay, so what we know then is that there are some new constraints that have been proposed. It does not preclude our ability to go forward on any of this stuff at this moment in time. And there will be arguing that will occur. That much we know for a fact.
Yes, very clear.
Okay, so at this point, so we're kind of back, so, but the fee part, so likewise with the fees, That's what their idea is, but that's not determining what we can do with respect to that.
Well, that's correct, but what you're also looking at is if the fees are limited to costs, and there's an argument about what exactly.
But I know, but that's, if we challenge it, that will not be the case. Because if there is stay is entered, that will not be the case. Let's think positively about the clarity and effectiveness of our arguments before whoever we have to argue about. So let's not assume that's going to apply to us, okay? Let's think bigger.
Can I make a comment there?
So, no, let me finish. So I don't see why we should assume that what they're saying will apply to us until it's set in law, after all the arguing ends, which we know will be a long time off.
There's an
So
important,
I don't think we should proceed on any of this stuff, assuming we don't have the authority. Someone tells us, some legitimate source tells us we do not have the authority, this is the law, get over it, okay, accept that. But until that occurs, let's not assume the worst, all right? So, yes, go ahead.
I think I agree with you there, but I just wanted to add to that, and I was going to get into this a little bit later, but we should challenge this in court and the FCC's recent order, and I think it's an important point that Mitzi has made that, separately, that if we want to prevail against these ordinance, the FCC's orders, we should have our own ordinance to demonstrate that we are taking action and that federal action is arbitrary and not necessary, fundamentally. There's no rational basis for it. And if we don't have an ordinance that stands up and meets the guide that Congress has issued, then the court could easily rule against us. So we are, I think, here compelled to take action to prevail in court, to have an example, evidence, really irrefutable evidence that local governments are moving forward and are sufficient to meet the intent of the federal law.
Also, if you remember, we've got the shadow of preemption from the state.
And the state, I think
And that starts in
that's
January.
another crucial element. I mean,
We've reviewed 2 drafts of what the industry would like to put forth, and it would
removes all of our,
remove everything.
I mean, it's whatever you're against here, the state law is far worse, and the FCC preemptions would be far worse. And again, having our own ordinance that resolves these issues the way that we feel is appropriate, and that is consistent with the basic federal, intent,
And
Yes.
I think it's-
will be our best argument, in my view, to either say no state law, or if they are intent upon moving forward the state law, then grandfathering us out, so that we have a better state law.
Yeah, so.
We don't have that state law applying in Montgomery County.
Right, so I think, one, absolutely to the point, that we strengthen our legal hand by actually having put a local solution in place. Because it adds fuel to the firemen of the argument that the reason why you have to have state or federal preemption is because there is no local action happening. So that, one, yes. 2, I think that we have crafted these things, and though some may describe it as torturous to get here, I think that we have a very long paper trail and legislative history to demonstrate that there were technical reasons, there were well-founded reasons why we picked specific things. Within the order itself, to both the point about the application, I fully agree with Chair Florine that we should take a positive attitude and presume that we will prevail. I also think that we are taking a look at it and we are crafting what we are doing so that even if we don't prevail, that we will succeed under the standards that are set forth. For the most part, what the standards really require is that you justify things. And frankly, I think that if you look at what Montgomery County spends annually on road maintenance, what we've spent installing those poles, what we spent operating them, what we spent, monitoring and plowing it, I think it's a good case to make an argument that whatever fee structure we pick, the national average is $1,500 a pole. That's sort of consistent with Baltimore's charging, somewhere there's discounts for volume. There's plenty of evidence as well. Boston, other cities where these fee structures have not prohibited growth, and the only thing the FCC is saying to us is, They got like 5 mayors to come in and say, well, if you didn't spend as much money in the big city, all that money would trickle down into the rural communities. And I think you have plenty of evidence to show from cell phone deployments and other things that has not happened. But back to your point, yes, we strengthen our legal hand by having a defendable process in place that balances the need to deploy, the fact that we cannot prohibit provision of service, with reasonable restrictions on location and height and reasonable opportunities for public notice and hearing if you are replacing poles that are shorter than 22 feet, which are the ones that are most problematic to put something in that stays in character with the neighborhood.
The only thing I would have to say is that there is nothing in the ZTA, and nor should there be, dealing with fees of any kind. This is not a fee,
Right. I understand.
Bill before
That's-
that.
But that's a separate matter. I'm
Correct.
really interested in. Okay, so I think we have, getting to the issues, I think we have been talking about why do anything now?
you sure have.
Let's go on to the next one. Why should we do nothing?
I'm sorry, Madam Chair, could I get back on the enforcement question before we go to the next issue? And that is, so I expressed my lack of confidence that,
That's going to come along here. Yeah. Okay, go ahead.
okay, thank you. I expressed my lack of confidence that the old poles will be removed, that there will be finger pointing and just nobody will ever get around to it. There's also a lot of lack of confidence that DPS will actually check every pole once it's installed to ensure that it is in conformance with whatever setback or other placement rules we put in place. How can we be confident that that will actually occur?
Because we're building the process to make sure that it occurs. And I think that what has gone before, there have been a variety of different ways that people have come in for requests for approvals. We now have completely revised our online application process. We are requiring that we have to know what the pole number is, what the GIS coordinates for that pole is, versus instead of an address, we're requiring that we have the height of the pole, the replacement pole, or any pole for that matter, but the distance from a building for the pole, all of this goes right into the online application. And as I indicated, we are also requiring that we will be setting up the final inspection, which is to make sure that once the plans are approved, because of course there's the review of the plans to make sure that there's conformity with what is in the ZTA, the permit will then be based on what is in conformity with the ZTA, and then the final inspection to make sure that it was done in that way. We will also be looking at what types of certifications we may be requiring, but we will be having a final inspection.
Each pole will be physically inspected?
There will be a final inspection for us to close out the permit, yes.
And
The other thing that I just wanted to make certain too is we're also building reports. We're gonna have 2 different reports that are gonna go to the Tower Committee. They'll be weekly. They will pull down the information that I just described to you that we're requiring to be provided to us. And we'll have a weekly report for the applications that are coming in so that the Tower Committee and DTS has a good handle on what's coming to us. So if there's a disconnect, it can be picked up. That's number 1. And then number 2, we will also be sending final permit closure reports to the Tower Committee as well.
They bothered to write out what the new procedure is, circle page 28 and 29 in the packet. I mean, one of the problems before was the lack of a right-of-way permit dealing with the Pepco pole. And I think they've completely cured that problem.
Okay, so along the lines of my earlier suggestion, I understand Crown Castle is not the only player in this game, but we've heard a lot from them, and they are very much in this game, so I'm going to refer to them as a proxy for any company that may be installing these devices. They want something from us, and we have some leverage. In return for being approved by the Tower Committee for placement, we've just recently agreed that we ought to draft language that says a condition of approval is that Crown Castle will have a contract in place ahead of time for the removal of the old pole. Similarly, I wonder if we can require that and this may be what Marilyn Praisner used to call belt and suspenders, maybe it's obvious on its face, but maybe as part of the reciprocal agreement that we will grant approval for placement of this structure, that you will agree that if it is misplaced, you will correct it. Because I could envision a situation where DPS says, sorry, it's 4 feet too close to the house. It should be, the setback ought to be X, and it's X minus 4, and you got to take it down and put it back up. And the company went to all this expense. These things are not cheap. And it says, the heck with you, we're not going to move it. We already put it up. We spent all this money. And we'll go to the FCC and complain if you try to make us do otherwise. So if there were some sort of agreement up front that we agree that it has to meet the specs, and if it's wrong, we'll fix it.
I'm not sure that's a zoning issue, though. I mean, it's really a condition of the permit. I don't know if you want to react to that.
So, yeah,
And then that could be enforceable in court.
But to me, it's the same enforcement question. So, we are going to enforce the law the way that it is drafted. And as Ms. Florine said, we will think about this positively, and this will be the law of the land for Montgomery County until somebody tells us
I
different.
acknowledge that maybe it's just
So-
repetitive, but my point is, I
Let her
apologize.
finish, okay? Let her finish her.
No, but so if it's not in the right place, well, first of all, and one of the things, and Jeff was alluding to this, we also, what we did not have we did issue right-of-way permits for Pepco poles, but what was not in place before was a zoning review relative to the right-of-way permits. We have added a zoning review as well, so that we will be making sure that we're capturing some of these issues as they relate to poles. With respect to the enforcement, if we find that it's not built the way that it is supposed to be, the remedies that we have would be the notice of violation, and if they fail to correct the violation, then we would go to court and we would seek an abatement order to get it corrected. I would note that one of the examples, we did look at all of the different examples. There was one that we found to be a violation, and we several months ago issued a notice of violation for that particular pole.
And was
And
it
we are
corrected?
working, we did, and we're working with them to try to
But
bring
what
it
harm
correction.
in having in the initial contract language an acknowledgement by the company that it will correct any errors, so that if we do have to enforce it in court, then you've got legally binding language that says if the government finds that this thing has been placed in the wrong place, we'll fix it. What harm in that?
So that's not a permitting enforcement issue. I would turn back to my colleague on that one, because,
Right, so I think let's sort of make sure that we're talking about the same things. One is, if the law requires one thing and you did something else, DPS has tools to enforce that you follow the law. The issue is specifically around the things with the utility poles. There are already contractors in place that can be used. The issue is is the contractor waiting for the existing, so take Verizon. Verizon's got an attachment on a Pepco pole. Crown has a contractor who's ready to do the work, or Pepco has a contractor to do the work, but they're waiting for Verizon. It is, I think, you'd have to look at to say, the ability for Crown, as an attacher to the second pole, to go in and remove a pole that is owned by Pepco, or to move attachments that are owned by Verizon, I think is a trickier thing to figure out. How do you do that? You could, I think, look at something that says either for Crown as a condition of what they can do. I see and I think we can try to figure out some way to get there. But as a matter of contract law, I think that it is very difficult to require one party to have responsibility for something of another party unless you're very careful about the way you draft that.
Yeah, and I would always advise great care in drafting.
But we can talk to,
Never
we can
recommend
talk to,
careless drafting.
we have been talking, and the double pole issue has been there. There's also, I know that there's agreements that Pepco and Verizon and Comcast were working on, in which they had agreements as to how they handled work that was sort of when the three of them were involved. So I think it's possible to figure what you're saying. I think that we could probably come up with a relatively short language. What I'm not certain of is whether that is something that goes in a zoning text
No, that's. we have to look into
amendment.
that. I understand.
But in terms of, yes, having that in any of the other property or the regulations, I think that yes, but I don't know that it would be appropriate to put into zoning.
Well, may I comment? Okay, a couple things. First of all, a few years ago, with the support of the council, I passed a law that we were hoping would promote the concept of dig once, that if you're going to tear up a street to put in a water main, you might as well at the same time put in your fiber optics, and you might as well at the same time repair the street just once, so you don't have to go back later when Washington Gas wants to go in, that we should coordinate. And we didn't have the authority to compel Washington Gas and WSSC and PEPCO and the telecommunications companies to coordinate. The only authority we had was to compel the Department of Transportation to seek coordination, but we had that authority. So the Department of Transportation has to do what the county council says, even if the utilities don't. And the result hasn't been perfect. Diane implements it, but it moved us somewhat forward in developing a GPS map of where all this work is going to be done. It still needs more work, but I went about it in the manner that utilized the authority that we had, which was only over Montgomery County Department of Transportation. Similarly, we have leverage prior to the approval of a tower. After the approval and erection of the tower, we have very little leverage. And we're talking about a context where we've just heard the Federal Communications Commission is trying to say local governments don't matter at all. You don't even exist. That what the ideal world for the FCC right now is companies go in, they put things wherever they want, they don't pay anything, and we all have fabulous 5G, and forget local government. So where local government has leverage is prior to the approval by local government of the erection of the tower. So that's where, both on the issue of removing the pole, but the separate issue of doing what DPS tells them to do. It seems to me that if you put language in the agreement before it's granted, then it might be more enforceable in court if a lot of these things have to be resolved in court. So even if it's redundant, obviously if DPS issues a notice of violation, you have to comply with it, unless you don't have to comply with it, unless we're in a world where local government doesn't matter.
If I may make a comment?
It's your meeting, Madam Chair.
We're talking about the neighborhood poles, the lower poles, would be subject to conditional use review.
Yes.
So that would have to adhere to whatever is
That
approved.
would not include any.
Very, very clearly, it's not, if it's a new pole, that's where the new poles would be, basically. And that's subject to already a regulatory review that's very highly site-specific. The other situation is existing poles that are already there. So you're not going to have the issue of putting them in the wrong place in that circumstance, because they're already there.
No, ma'am, you're replacing an old pole with a new pole. I'm sorry.
Well,
It's not the
saying,
existing pole.
the pole is there, here's the pole, here's the new one,
It's 2 feet, it's within 2 feet.
within 2 feet
Sure,
of
but the
that.
2 feet could be within the 30 feet. Look, you don't think people challenge things that they're a
I'm just
foot
saying, we are talking about, again, angels on the head of a pin, but that is something that DPS is committed to verifying under any circumstance.
I would like to request, in
You know,
the same manner that the chair requested, that we try to draft something having to do with the second pole, that we also draft something, and I understand it may be a bill rather than a ZTA, that says that before approval is granted, there's an understanding up front that any order by DPS will be complied with.
Can I just, I just want to make sure, I want to clarify. I think I heard you say two things. One is you need to resolve the issue of whether we can get the wireless providers to have a contract to remove the existing poles so that there are
Yeah.
no double poles. And
Yes.
two, you would like language in a contract that would say that if a company installs its equipment incorrectly or on the wrong pole, it would remove and reinstall so that it would be in compliance.
Well stated. That's just what I'm looking for.
Okay.
May I comment quickly?
We'll look at
First,
that.
thank you very much, and I appreciate that. On the first point, it can also address what Ms. Herrera was just talking about, which is, okay, fine, so you got an agreement with Verizon, or you got an agreement with PEPCO, but it turns out Verizon has a box on there and Verizon doesn't want to. Well, fine. For the erection of each device, you scope out ahead of time how much freight is it carrying, and then whatever companies are responsible for that freight, you've worked it out ahead of time before you get the approval for the erection of the new device.
Yeah, we'll look at that.
Thank you.
Okay, let's move on to the other issues that came up at the public hearing. Why
Right.
should the council do nothing? We heard from folks who disputed this need, and we heard from folks concerned about property values. And we've already talked about the ability to assure that a tenant is antennas meet the conditions of approval. I think that's been pretty much chewed over here. So can you folks respond to the need issue and the property value issue?
Again, for need, I did have a chart on expected wireless use. It goes, it's expected to be 4 times the amount of usage from 2017 to 2021. I don't think the wireless folk determine where that usage lies, but it looks like most of that is for video usage, but that's what people want to do. And I don't know that there's any denying the expansion of wireless communication. We have it in our pockets all the way, and our refrigerators will have them shortly. And our cars will be more dependent on it. So I don't think there's a way to say that there is no need. And this really goes to, does the county want to lead or follow in this area? Do we want to be permissive of this technology, or do we want to be an impediment to this technology? And I suspect we should be a leader rather than an impediment, and I would recommend that the council go forward with this ETA.
Mr. Ermy?
I just want to say that the county executive feels strongly that this is very absolutely necessary for our economic vitality. We want to be a connected community that can attract the best leading-edge companies that need this kind of technology. We also want to be able to attract the talent that is expecting that this technology exists where they're going to go to work, where they're going to go to live, and where they're going to go to play. So I think that if we want to be economically viable going forward, we really have to look at how we can do this while we're also protecting, our residents. And I think that was the balance that we really tried to strike here, was to make it viable for the providers to be able to come in and bring us the best technology and be at the leading edge, as Jeff said. And while we're also trying to protect our neighborhoods, and again, that the state preemption very much worries the county executive. As you know, he's stated in his memo, he's worried that if we do nothing, and we go into Annapolis this year, we're working with other counties, and they feel the same way. And I think it's a very strong argument that we have against preemption. But if none of us do anything, then we may lose that argument.
Okay, so what do you have to say with respect to the property value issue?
Again, what I said is, I don't know if it's number 1 or number 2, but number 1 is, I don't know the answer to that. I know that there's been lots of literature on taller poles, where you have major towers. It's gone both ways on whether it's a benefit or a burden. So I don't know the answer to that, and we're dealing with mostly very much shorter poles than what's been in the literature and what's been tested in court. The second thing is, for the most part, this is in the
We're not talking about telephone poles here. We're not talking about big strings of wires hanging off in the air. This is different.
No, these are the complaint was really the macro towers was where most
Well,
of
the evidence is about macro towers, not
Right.
smalls. But even, if I may,
Well, let's hear from Mr.
okay, yeah.
Mr. Zients right now.
I mean, I just think this is a different category of stuff, and I don't know the answer to it. Certainly, some people may not want to buy a house near it. Some people would only buy a house near it.
Some people won't buy a house in a neighborhood that doesn't have adequate cell coverage.
Nobody will buy my house today, I don't know. But I digress.
Pretty crummy cell coverage at my house.
There you go. But
Don't
in any, here's the other second point. We're dealing 90% a year of what you can do in the right-of-way, for the most part. And within the right-of-way, we have never determined whether what we're doing is a plus or a minus to the property against it. Within the right-of-way, we have an assumption that we're putting there because it benefits the public, particularly the people near the right-of-way. So when we do traffic signals or street signs or street lights, we're not asking that question at all. But I don't know that I can answer it definitively, and I don't know that you should answer it.
And that most of the data that you allude to in your memo is based on the
Taller tower.
tall towers that are 100 feet or more. The ones were more traditional towers. Mr. Leventhal?
Yeah. So having thought about this from a broad perspective, imagine if we were debating installing natural gas lines for the first time. Seriously. No one would want one in their house. They might blow up. They really might blow up.
They did in Massachusetts.
And somehow, I am actually interested in sort of a very short history of how utility lines ever were laid in Maryland. Because, I know that, there was opposition from landowners to railroads. I mean, there are, fundamental things that take up space without which civilization wouldn't be where it is today. I mean, if I didn't have natural gas, I couldn't cook.
Right.
But if you asked me, do you want a line with explosive gas coming into your home?
Right.
I might say, no, I don't want it.
Right.
So,
So typically, you had either state or federal preemption, which allows those things to go in. But a caveat of that is that they also required service to every address.
well, yes. So that's another push that we ought to be thinking about in terms of state legislation.
Oh, yeah.
Is where are we ensuring that everyone has access? But from the standpoint of property values going down, I think you could make exactly that argument. I do not want explosive gas coming in a pipe into my kitchen, and it will hurt my property value. No one will want to live in a home served by explosive gas, except gas is actually preferable to electric. I mean, I'd rather cook with
Right.
gas. So,
Well, if I could draw your attention to Circle 38, there's a photo that's there, and there are other photos, but to Jeff's point, that where we have things in the right-of-way, we typically have not, in any of those cases, looked to see what the value is on the abutting property. So what you see on the left there, that is electrical equipment that Pepco has been able to install. The size of the antenna that would be permitted is roughly the same, or a little less. So we've had an issue where things are attached to utility poles, and we have not asked that question. And that's a point I would make, is just, there's other visuals, particularly if you live in areas in down county, where following the derecho, I know the council had lots of discussions about this because it did involve the trees, but there are lots of places on Georgia Avenue where they came in and they put in 70-foot poles because they did it for electrical reliability. And primarily the reason why we have taken a more light regulatory touch on this is because it was deemed that the point of doing it is to ensure that people have reliable electrical service.
sure. So in any event, if before it goes to full council, I think the whole council would benefit from a little short history lesson.
Sure.
Because, looking at this Pepco poll, same deal. Like, I could get by without electricity. I don't, some people might say, I don't want an ugly wooden pole in front of my house. It's ugly, and it really is ugly. And I'd rather just not have it. No, thank you. I want opt-out. I don't need electricity. I can watch TV next door. I'm exaggerating, but not much.
But in fact,
So-
the county we added a requirement that said that any subdivision approved after July 1st, 1967, had to have underground
Yeah,
utility
right.
box.
Okay, so just a little history lesson about how did we get natural gas? How did we get electric lines?
Well,
Let me just tell you a little bit of history. The
Yeah.
first subdivision case, the challenge was somebody wanted to put a sewer line in a public right-of-way, and they objected to the thought of that going by their house.
Sure.
And
Same
that was
point.
the first
Right.
case, and the court said, no problem here.
well, if we're going to talk about history, the town of Garrett Park incorporated itself to preclude indoor plumbing. Because at that point in time, there was typhoid, I think, in Kensington. And they felt that that was bringing, I think it was typhoid or cholera, something bad. And they felt that, you know, this new process would introduce disease into the family life. So, you know,
That's
we
germane. That's
historically
germane,
have concerns about new things.
Yeah.
The town did get over it, everybody. It took a while, but it's a community that likes a good argument. And that would be
Well, that's
true
fine.
of Montgomery County, wouldn't it?
That is my point. But how and when were those, of the utilities that do serve, all of which are dangerous, electric lines can electrocute you, gas can blow up, as we've seen, you know, so just a little history lesson. When and how were those things authorized?
Okay.
Actually, it'd be a pretty good cable show. Anyways, okay. So we have that. Public health. We know, let's just say it again for the record.
For the record, this is an area you as the council are preempted from considering. If you consider it, whatever you do will be voided by the court. The one case we had in the Fourth Circuit was where the commissioners disapproved a poll. Within the list of the reasons, they had multiple reasons. One of the reasons was health. And the court said because health was included in that list at all, the denial cannot stand. So they overturned that. There's been some argument in California that because it says you can't, it doesn't involve the environmental effects, it doesn't include human health. Well, the Fourth Circuit here said environmental effects includes human health. So we have that determined as well. So if you consider it, you'll be ineffective.
Okay. So we're stuck.
You're stuck,
And we know that people care very passionately about this.
right?
But that is not an avenue that we can proceed down. Okay. Next up, well, we talked about the issue, well, let's talk about the next issue. Why don't we require conditional use for everything?
And I think that the ZTA as proposed creates a good balance here. Before we allowed cell towers at all, there was no setback for poles on existing structures. Within the small cell ZTA that we did in, I think it was 2012, we put in a 60-foot limit. When you looked at that, I don't know that anybody recognized that that would have the effect that it had on existing utility poles. So this ZTA corrects that and allows that as of right if you're at least 30 feet away. That seems like a reasonable split, because on the shorter pole, again, you do allow conditional use, but there should be some allowance as of right where you want to direct these. The bigger streets and on wooden poles are and should be the easiest way to achieve this.
So on the bigger streets issue, how do we define that?
We're really doing this by defining it on the pole size itself and not by the street type.
So that, it's where those poles are,
Correct.
and they're on more
Heavily,
More heavily
they're on the
trafficked.
bigger streets. You won't find a Cobra headlight on a background neighborhood street. You just won't find it.
okay.
Just one inclusion to that. In terms of expansion of those poles, on the streets that are 65 feet in width or shorter, then you get a shorter or a smaller up to 6 feet, I believe, and increase in the
Right.
pole height versus 15 feet if it's a right of way or pavement greater than 65 feet. So Just-
Yeah, but it relates, not street classification, but the width of the street.
Right.
So, that, and it does regulate a little bit the difference in height, that is true. So we make that difference as well.
Okay.
All right, where are we?
Then, well, remind us about what the city of Gaithersburg does. That's interesting.
Gaithersburg took a unique approach. It said, where we have utility poles, we'll regulate that by franchise. We'll have 100 pages of conditions to say what we will allow on that street pole and how we, that utility pole and how it should go forward with a franchise agreement.
But that would be a permitted use in Gaithersburg,
It's permitted under the franchise.
but not as a community conversation.
Right, but that franchise agreement, nobody,
Franchise
so
agreement.
far as I know, nobody has agreed under that franchise agreement yet.
But the point is that that would be handled by the city directly as a permitting process.
Yeah,
Okay.
So
On
it's a
that point.
franchise agreement? So if someone wants to come in and, the company wants to come in and replace a certain number of poles, they would sign an agreement with the city, is that?
well, it's a franchise agreement to use their right-of-way, just like we have.
We have franchise agreements also, so what's the distinction?
They have a separate set of regulations to use the pole,
Right,
and they have a separate set of regulations that are enforcing the zoning code. But I think in Jeff's packet, what he noted is that they also allow them to be attached to houses.
Alright. Well, we're not contemplating that.
No.
But what's your view of the Gaithersburg ordinance as far as the rules for attachments to poles?
I think that they are working through the implementation issues. There's a lot of back and forth conversation about whether they would amend some of those. I think that there will be other conversations that we have to try to make it, one of the arguments that's lobbied against having local regulations is that means I have to figure out what to do in multiple different places. A lot of the Maryland municipalities and the counties are working together to make it easy to understand what is happening in one jurisdiction versus the other. Prince George's County has told us that they are looking at our regulations and they'd like to adopt something very similar to it. Rockville has said,
Zoning Ordinance?
our zoning ordinance, right, Rockville, and in fact, I just had a conversation yesterday with their office of their county executive, and but they are looking to see what we're doing. Similarly, Rockville is looking to do that, and we would like to have a conversation with Gaithersburg, because what we'd like to have is that it's a relatively straightforward process. Everybody has their rules in place, and you understand. And it's not that, they may vary slightly, but it's easy to understand from one place to the next. The Up County is a little bit unique in the fact that you can go from the county to Rockville to Gaithersburg to the county to Gaithersburg within a few miles.
And they don't zone their right-of-way, right?
that's correct, that's
What
why
does
they
that
have these.
mean?
Well, literally, underlying our right-of-way is an R90, R60, or whatever zone. What they do is they zone up to the right-of-way line and literally leave that area unzoned. So it's not regulated by zoning at all,
I see.
and ours is. And that's why with Gaithersburg, where they allow the antennas on single-family homes, that's in their zoning code.
So to the extent that they would have wanted to establish a zoning standard, or would want, it sounds like they're, it's an ongoing process. They would actually have to start to do something they haven't done in the past, which is to zone in the right-of-way.
They could regulate through these agreements and their permitting process within their right-of-way. They don't really have to zone.
Okay.
It's just different
Just
case.
different. I mean, it's a regulatory, that's why they're focused on the regulatory solution as opposed to a zoning solution.
Right,
So it's a permitted use
right.
by
I mean,
franchise, through a franchise agreement.
yeah, there are lots of conditions. I can't tell you that I know them all.
Madam
which
Chair?
is, just to wrap up from my own thoughts, it's, you know, again, I tend to think what we want is clean, simple rules that are visible and transparent, and
Yes, and actually, under the FCC rules, that's sort of the carve-out of a safe haven, is that you've said in advance what these requirements are.
all right.
Madam Chair?
Okay, George?
Yeah. So I appreciate the discussion of Gaithersburg and Prince George's County. I've heard a lot about both of those jurisdictions. I want to remind Mr. Zients and the chair of our recent experience with the ZTA on breweries and wineries and cideries and meaderies and distilleries, which I thought was just excellently crafted, and I really like it, and we had a great conversation here. And it got to the full council, and it's controversial, and council members who are not on this committee, 6 of them, were not well briefed and started from zero with some very basic questions about why should we do this, why do we need this, why can't it wait, you know. So the same thing's going to happen here. So when I ask for, so, you know, we may be reasoning our way through these thorny issues, and we may or may not report something out of this committee, but when it gets to the full council, we're going to have to start again from zero, and there's going to be some very fundamental questions. And so the question I asked about the history of how other utilities were put in people's neighborhoods, I think is useful not only for me, but I would like it. And secondly, I've been asking for a long time for an explanation of what other jurisdictions are doing. This packet doesn't contain that. So some of the community advocates have said, well, why don't you just track what Prince George's is doing? And it's my understanding Prince George's has a 60-foot setback, and I understand that it is industry's point of view that a 60-foot setback simply will not provide opportunities for adequate coverage, and therefore FCC will come in and overturn that. There's a gentleman in the audience with shaking his head, no, that's wrong. Every single assertion anybody makes here, someone is going to say, no, that's wrong. So I would ask audience members to understand, we know there's different points of view on all of these things. However, it would be useful to have a little précis of where a jurisdiction, either here or elsewhere, because 5G is being installed all around the world, and certainly in all 50 states, it would be helpful to have a little reference to say, here's what Prince George's has done, here's what City of Gaithersburg has done, where jurisdictions have actually done something. I don't care, San Mateo, California, I don't care, but just a comparison. Are we in the mid-range? Is a 30-foot setback about right for what other people are doing? Because that, so first of all, I've been asking for that for a long time, description of what other jurisdictions are doing here. Secondly, obviously, and if I don't suggest it, someone will, there will be proposals for compromise. Okay, if 60 is too much, but 30 is too little, what about 45? It's an obvious question. So we are going to need to map out a range of options on setback. And if you don't do it in the PHED committee, you know, I can just predict which council member will come up with the, I'm just going to go ahead and say it, the Berliner compromise. Someone's going to ask you for 45 feet, so you might as well be prepared for that question, whether we raise it in committee or in full council.
Well, and that big,
But I've been here a long time.
Well,
I've seen this movie before.
we've seen this movie before, and
Yeah.
that's part of the challenge that we have in our timing. That's the council president's challenge here, because the council has to act in this month. So just,
Wouldn't it be nice if our colleagues with the council would, you know,
so
look
many
to
things would
us
be
and
nice.
our thoughtful leadership?
But you wouldn't do that. You wouldn't do that with the,
Nope, you never do.
you weren't on.
So, just putting that to one side, that's a background concern in all this. I really regret this schedule. I think it's unfair to the community, frankly. I think it's unfair to us to not have all the moving parts laid out so everyone understands it. I'm just saying, but let's continue to work through this.
May I make a short observation, Madam Chair?
No, let's just get through this packet here.
Just let the record reflect that a member of the committee sought recognition and was denied
Indeed.
recognition by
Okay,
the
you have
chair.
plenty of
Could
time when we're
record
done
please
with the
reflect
packet here. Okay, next one. Should be, antennas be kept out of the right-of-way. I think we've
That's
sort of
what we
chewed
just
over
did
that.
with describing what Gaithersburg does.
Yeah, oh, right, okay. Compatibility.
Compatibility, and a lot of this went to the size of equipment and antennas going on these poles. I tried to describe that in my overview to say we are requiring something more than the minimum size that could accommodate a single user. There are illustrations, circle page 27, on the size of equipment box depending upon how many carriers you want. Again, on circle page 27, the three carrier box on the right is sort of what we would envision on the base of the pole. So it would be, it's 26 by 26 by 48 at the base of the pole. We are requiring equipment at the base of the pole. And we're doing this really so that we could accommodate co-location. We don't want to create more of these things than we need to. So it's a compromise between the size and our aspects of co-location.
And presumably, they could take some other form.
They could. The bigger size you
Just
allow.
The cubic foot issue would control.
All right, number one, cubic feet gives some variability. Number two, the larger the size you allow, the more variance they can have. In the Ocean City, they have the 4 carrier routine. They went for that hexagon look, which is the other illustration on circle page 27. It's bigger. I don't know that it looks better, but it's certainly more massive than what we're allowing. It does allow for 4 carriers.
Question?
So that's bigger than what would be
That's
permitted.
bigger than, yeah.
Okay. George?
Is there any real economic reason to think that a wireless company would install a structure that is larger than it needs to transmit 5G? Is there a reason to fear that you might end up with larger structures than are actually necessary to fulfill the function? Wouldn't you think that the larger the structure, the greater the cost, and that it's in the company's own interest to install only the minimum that they need to install?
I think within terms of this box, they would want as much flexibility as they can. So if you didn't limit the cubic feet in some way, they would want to be able to accommodate the 4 national carriers that exist. So yeah, you could not have a limit on it, but I don't know that that's a good idea either.
Okay, but does that then not run afoul of the FCC's?
No, as long as we allow that other pole, if you can't locate, and we still allow a second pole somewhere there, that doesn't run afoul of the FCC, and we.
Well, but that doesn't suit anybody's purpose. Now you've got 2 ugly structures instead of 1.
May I comment on that? This is where I think the conditional use process becomes very valuable, because whether a neighborhood is better off with a larger base structure and 1 fewer poles, or a narrower base structure and maybe an additional pole, that is really, it's somewhat in the eye of the beholder, but the base structure is pretty big. So if it was my neighborhood, I might actually rather have smaller poles, smaller base structures, and a few more of them personally. So but again, I'm not making that judgment. I'm just saying, I think this is a good use of the conditional use process so that question can be evaluated. If you don't have a location for a big base structure, you know, that blends in nicely, you might be able to blend in 2 poles more easily. So I don't know. It's just something that's up for negotiation and input.
Okay. So what's so special about 22 feet?
Again, we've been through this a little bit on what it means. It's really 22 feet and wooden utility poles. If you thought it a benefit for you, the DTS has mapped every street light in the county and determined whether it would be a conditional use or a permitted use. And basically, the pattern look is that along main corridors of the county, it would be permitted among the newer
Well,
subdivisions.
what's magical about 22? Why not 20? Why not 30?
There you go.
All right, so the street lights, and this really more pertains to street lights than utility poles. For street lights, there are roughly 2 classes of DOT freestanding street lights. They're either gonna be 14 feet tall or they're 25 feet tall. So one is, it's a clear distinction of, there's the taller, either the cantilevered kind of cobra head that's a spun aluminum, or there's a bronze one, those are in the tall pole class. The other ones that look a little colonial, those are in the shorter class. The 22 feet is designed that this equipment has to be a certain amount of height above ground. So above ground level, rather. So the idea is that where you have the shorter pole today, to the top of the antenna, 22 feet should be enough to satisfy the need that you have for a relatively low-power antenna that would be deployed in a residential
And
neighborhood.
you'd have the box at the bottom.
You have the box at the bottom. In the residential neighborhood, you would, and then the idea is that you can increase it. That gives you enough that additional, so if you have a 14-foot pole right now, that would mean you get an additional 8 feet. You have 4 foot for the antenna. There's a 1 foot, so roughly 2 feet of connector, and that gives you enough ability that you've got a little bit of play in there, but it creates a hard and enforceable cap, which was the other reason why we picked a firm number, because it made it easier if you were trying to say, well, based on what was there and what you could add to it, it was relatively easy to enforce that. Similarly, or I guess relatedly, where we were talking about utility poles, where we put in a specific number of feet, because you can measure and you can have a distance of what the current pole height is on the utility pole, and that's a little bit less likely to have variance. So the standard that we picked for the 22 is designed because we have 2 classes of poles, so it creates a clear delineation between them. And 2, we could create a hard cap on the pole height increase for the shorter poles.
So for the taller poles, the box would go up high?
The taller poles, there's roughly 2 designs, and those may evolve over time. In one configuration, you don't actually have to add any height to the pole, and you can add the antennas. You could put a new pole in that's stronger, that's the same height, and roughly around the pole, below the cantilevered arm, you could place the antennas.
Up high?
Up high. The alternate design is that you could place the antenna on top of the pole, so it would extend up, and that's where we came.
Up high?
Yes.
We're not talking about the ground level box.
So there's antenna and there's equipment. We would allow, with DOT consent, that you could put the equipment up higher. If you put the equipment up higher, you don't have to have a fan in there because you can have air cooling, and generally you can have slimmer line equipment. If you put equipment in the base, you need to have more space because you have a cooling fan. You have to harden the base so that it, against people coming and kicking it, and you also need to add additional bulk to it so that it can support the weight of the pole. That's why the change is in there, that if it's in the base, it's slightly larger, if it's on the pole, it's smaller.
I see. So there's no hard and fast rule as to where the equipment box would be located on the taller poles.
There is not, however, to the extent that those are poles that we own, those are things that we can specify in the license agreement to use our poles, or have a set of design standards that we attach, and then.
Okay, thank you. Okay, then, what's with the 30-foot setback issue?
I started to describe how this went on where the 60-foot first came from. It was first in that ZTA that allowed small cell towers. It set up an unusual situation where you could do a bigger antenna on an existing structure, but not a smaller antenna. So we've been, there's some effort here to correct that. 60 foot is certainly larger than the setbacks of most residential zones. It would, if you had it as an absolute standard, it would lead to large areas of the county where it took off the table a lot of right-of-way. We could show you that, but I think it's enough to say that.
It would take off large, vast portions of the county that would no longer be
You could not
Essentially
service,
eligible.
you could not service them, use the right-of-way for any of the,
What your memo says that a 60-foot setback would prohibit antennas on 37,000 of the 75,000 streetlights.
that's correct.
So that's kind of a big
Kind
concern.
of your basic big deal.
It's half of the
Half of
county's.
them.
But what I suggest that you can do within these residential areas is that where the setback is less than 60 feet, and it's already subject to conditional use because you're dealing with shorter poles, you could have the hearing examiner allow going down to 30 feet if it's necessary to service the area. So it would
You could start out with a presumption of 60 feet.
start out with a presumption of 60
continue with the
feet,
argument.
allow it to go to 30 feet for those poles where you're already in the conditional use approach.
Well, why don't we do that?
Rather than the 10 feet.
Then the,
Rather than going, yeah, right now you could go down to 10 feet.
well, why didn't you propose that? That makes
I
perfect
sort of did.
You did.
we
You
should
did.
do.
The county executive people
And-
did.
And the county executive is fine with that.
Okay, well, let's do that. That would help a lot, I
Okay.
think.
I think that's a good protective move. It would mean that you only go down to 30 feet where you,
And you have to
go to
make the
10 feet.
case.
and you don't go down, you don't go to
20
10 feet,
You don't go to 10 feet. 30 feet is
the lower.
the closest it can be.
And you'd have to make the case that was required by whatever you had to prove, but that, the presumption would be, you'd start with 60, as, that's what's required, and the applicant, because there would be a public hearing, and you could argue about it, but that would probably narrow the situations to those cases where it's absolutely necessary, and that would be a full-scale debate over the competing interests. That
So-
seems like a good solution.
So, question?
Yes.
Right. My experience over the last couple of years on this issue is that when we propose any changes to the setbacks that are in front of us, the industry says it just can't work. We just can't get the coverage, won't work. And I predict that if you completely preclude 10-foot setbacks, that's what they'll say. But we'll find out. My experience is also is that in every case, 100% of everything industry says, my very well-informed constituents who have a background in consumer affairs and work for the FCC and extremely knowledgeable, says everything the industry says is not true. So it's enormously difficult, not only for me, remember, because we're going to wrestle through this in Fed, and then you got 6 other council members who are going to be encountering it for the first time. It's hard to assess what is true. Both sides say that the other side is not accurate, and that you could get by. For example, it's been asserted to me from very knowledgeable people that a 60-foot setback would really be fine, that industry just wants more leeway, but they could do it with 60 feet. And they say they can, and I know you believe that they can. So how are we independently assessing what coverage is indeed necessary, not just taking it on faith that what industry says is true, or on the other hand, taking it on faith that what the neighborhood advocates say is true. And in that regard, again, I'm going to repeat myself because I didn't get a response. You are going to be asked, if not by me, by others, what about a 45-foot? What about some other compromise? So how are we going to assess those suggestions, which will surely be made? I'm not going to suggest it here in committee, but I assure you, if 60's too much and 30's too little, by golly, it's so obvious. Some council members are going to say, well, 45, I fixed it. I'm the champion now. I'm the hero, 45.
So I agree with you. There's competing and the need to have some facts to evaluate it. So what we did is DTS had previously created an application that mapped all of the streetlights. We had done that because people reported an outage of it and you didn't want to have 10 complaints. Park and Planning was able to take that data and overlay it. And I believe Jeff is now showing you. So this is a map that's on the MC Atlas. And what Park and Planning went through is these red circles. And Jeff, if we could shift the map to show more of Silver Spring for a moment. And if we can zoom in, maybe somewhere in Silver Spring would be fine.
Try.
All right, So what those blue, so in the zoning ordinance, just so we're clear, and we did this before we had Jeff's change. Each of those, wait, just go, if you move it a little bit to the left, Jeff, it'd be helpful. No, other way, other left. There you go, stop.
The other
Stop. Stop. Okay. These red circles are showing you any place where the pole is closer than 60 feet. For the most part, these are tall poles that would be permitted as a limited use if they were at least 30 feet back. So what the blue is showing you is those poles are not 30 feet back, and the green, those are 30 feet back. So one is,
Sorry, so the blue is closer than 30 feet?
correct. So right now, we did not have any language in there that says, if you have a pole that's taller than 22 feet and it is closer than 30 feet to a house, there is no process for you to use that pole. There's no, we did not add that in a conditional use.
Not do that.
Correct. So the conditional use only applied if the pole is shorter than 22 feet. So right now, it's either yes or no for these most of these are tall wooden utility poles. If it is at least 22 feet tall, if it's closer than 30 feet in a residential area, you cannot use it. And what this is showing you is all of those blue ones are poles that are closer than 30 feet. The green ones are ones that are at least 30 feet away.
Okay, but what is, okay,
But the red circles are saying is if you had to say that the thing has to be 60 feet back, all those red circles show you things that are closer than 60 feet. And you can see that in this area, there are relatively few things that you can use, particularly in these areas where we built the utility poles much closer to the house.
okay, I'm going to repeat it because it helps me to
Okay.
try to understand it. Every single one of the red circles, whether the donut hole is green or whether it's blue, is less than 60 feet from a house.
Yes.
Got it.
So in this area, you could see here that while there are a few poles that you could use, you run into the potential problem that you would preempt using a lot of these, we would prohibit, and we would run up against the FCC challenge, because some of these, depending on, there's been some confusion, 5G means many things. You can use it as a fixed wireless, but in this case, for your phone to work, right? These things are designed that they have roughly a coverage area of about 350 feet. So you could see that in this area, and at the bottom, you can see that says that that's 100 feet, right? So you can see that you'll start to run into problems, particularly if you zoom down in some of these other areas.
But excuse me, but those are situations, are they not, where they would be conditional uses?
If the pole is taller than 22 feet.
It would
and
not.
30 feet, it would be limited use.
It would be a limited use, and it would not be subject to the 60-foot
Existing poles.
point. What we're talking about, as I understood, are the situations where there are conditional uses.
Right, let me,
Conditional uses, the applicant would have to make the case that the world would come to an end if they didn't have a lesser setback. Is that correct? That's what this language would achieve.
Correct. And-
Correct, but I think what Mitzi was trying to address was Mr. Leventhal's question just generally about the 60-foot setbacks versus 45 versus
they're-
30 versus.
You know,
And
you can parse this lots of ways. There are two different categories here. The taller poles would not be subject to this. It would be the shorter poles, because they're existing. It would be the shorter poles that would be subject to this. A standard of 60 feet, unless you can prove you satisfy all these requirements.
Right,
Yes.
but I think what she was
Yeah.
trying to address again is Mr. Leventhal's question that would 60 feet across the county preclude the
Okay.
service?
Be ready for the 45-foot question.
Yeah, well, so what we did is that we've actually, and I appreciate it, but actually in the mapping data that we looked at, because initially we had proposed this to say it could be 30 feet reduced down to 10. And if you zoom in some of the upper neighborhoods, or you got to go towards like Gaithersburg, Germantown, the dark browns,
Okay, you know.
The dark brown circles are showing you poles that are shorter than, they're closer than 30 feet, but at least 10 feet. And what we found is these orange poles are showing you ones that are at least 30 feet from the house. So in our view, you don't have to have a requirement that you reduce it less than the 30 feet. You can, as long as there's something else you could use. Now, we wanted to leave some leeway if there was some reason why you wanted to do it for aesthetic reasons, but at least in my opinion, I don't believe that we would preclude service by saying it's got to be a minimum of 30 feet. Jeff, if we can turn on the bottom layer. Okay, let's just make sure that street light poles is turned on.
Streetlight pole is on.
Okay, so you can see that there's, yeah, because you can see that there's one. So in the up county, ironically, they have shorter poles, but they're further from houses. And actually, what this is showing you, if this data is correct, all of these poles are at least 60 feet from the house, because they would have a red circle on them if they weren't.
They're at least 60 feet from the house.
Correct. Because you can see this layer
Well, that's because it's larger
right
lots.
here,
Right.
So this is
Sure.
one, this is one.
Right, so in larger lot zones, you're going to have,
Yes, yes.
right, it's going to be
So-
easier to do.
And so, so the way that this has come to be is that it's a conditional use. The pole is shorter than 22 feet.
Okay,
And it's a limited use if it's taller. And then sort of within those two subcategories, sort of yes or no as to whether you meet the setback limit. That's what we're saying is that Jeff's proposal was pretty ingenious because in some areas, now in this one,
right.
you know, I'm wondering, if you zoom out one, Jeff, I'm wondering if
No,
actually it's a setting in the layers.
The red doesn't show up if you zoom in too much.
Okay, so
this-
we have to address, okay, so let's stay at this for a minute. Now, okay, now with this data, right, what this would tell you is there are very few poles in there that meet the 60-foot setback. But you could see, so for example, you may come in and say, this is the pole that I selected to use because it meets a 60-foot setback. And the reason I didn't pick these other ones is because they were shorter.
Sure,
But if you were in an area, say like here,
there aren't any.
right, and you have to go to conditional use to say, I need to use this pole and I need the setback to be less than 60 feet because there's nothing else here that I could use,
Right.
right? So that's what Jeff's, which would, and frankly, looking at the data and looking at that, it seems a very reasonable approach.
Madam Chair?
You've got the floor.
Okay. This is an unusually contentious and difficult and hard to understand issue zoning by its nature is contentious and hard to understand, and this is really on the high end. And I feel pretty good. I mean, I feel like I'm actually understanding what we're talking about, but it took me a while to get here. I want to address what Joy said, that the county executive feels that this is an urgent priority from the standpoint of economic development, because I can see that in the urban centers. It's hard for me to feel a great, and I'm all for economic competitiveness, you bet. We want to be economically competitive. We want to be in the 21st century. We want new employers to locate here. We're still in the running for Amazon. Who knows what'll happen, et cetera, et cetera. Okay. But it's hard for me to believe that in the rolling hills of Travilla, it's all that urgent that your download speeds be absolutely fabulous. I mean, people are going to weigh various factors in deciding where to locate a company, and in further out residential areas, I just don't buy that it's all that urgent. So that's observation number one. Stand by. Okay. Observation number two, and again, anticipating that you're going to get these questions whether you face them from me or not. Other council members will ask them, so you better prepare for them. Could you not, because you're showing me a map, so I get that in Silver Spring, the houses are really closely spaced. It's an R90 zone. So, you're not going to find a place where anything is 60 feet from anything else. Everybody lives right next to each other. But in Travilla, it's larger lots. And we have the capability to distinguish between zones. We don't actually have to adopt a uniform standard for every zone, or do we? That's my second question. Because where the issue arises, where it's really contentious, are in newer subdivisions where the utilities are undergrounded. And not in every case, but in this case, the newer subdivisions are in larger lot zones. So could we not have a different approach? And, you know, there's more of those dots without the red circles in the larger lot zones for obvious reasons, because you're 60 feet away much more easily on a single lot. Could we not have a different approach depending on the lot size that might then ameliorate some of the anxiety being experienced by some of these communities that don't already have poles in existence where,
Right.
you know, they were undergrounded?
So let me try to answer that last question
Just
first.
hold on just a second, but the way people work is changing. I mean, the number of people I run into on a regular basis, whether or not I'm campaigning, who work from home, who run significant consultant operations from home, who are trading on the stock exchange from home, who require access to good data from home, whether they're in Silver Spring or Potomac or Travilla or Damascus, it's widespread. It's actually helping with some of our traffic issues. But, I mean, this issue, this public policy issue, is endemic regardless of your location, I think. So I think we need to be careful about thinking that lifestyle choices are easily assumable with respect to this.
Okay, but as the chair knows, every assertion is going to be challenged.
Well,
from
you
one
know,
side.
look, we're going to do what we think is right.
Let me know when I
We
have
can
the floor,
only do
Madam Chair. Do I have the floor?
Go ahead.
Thank you. So, I mean, the counter to that is that those homes where people are working have broadband in the ground, and they don't need to rely on wireless transmission. Wi-Fi isn't going to go away. People will still be able to get access to data without wireless transmission, and people will look, I'm not, you can take it from me, or you can take it from the other 6 council members. These questions are going to arise, so you can
Right.
either indulge it now or not, or the
So-
chair can recognize me to ask a question that my constituents are asking me every day,
So-
or not.
so I think- okay, so I think-
So the point being that the argument that it is absolutely urgent to have the highest transmission speed, the highest capability to download wireless, not just from your router, not just from your FiOS, but you also have to have wireless in every neighborhood, everywhere, is disputable. I mean, that's all I'm saying. There's another point of view. It may not necessarily be the case. That's all. So having said that, my question remains, and whether or not it's economically urgent, whether or not it's absolutely critical to economic competition. Let's say it is, that 10, 15 years from now, everybody will want to be able to, you know, watch a 3-hour movie on their phone while they're driving around, and then they'll have a crash and then they'll die. But in any event, they need this wireless speed. And I get the Internet of Things, I understand smart vehicles, I'm hearing all this, I understand all this. So you have to have it, okay? But even so, you could have a different approach to setbacks in large lot zones. That doesn't negate that question.
Well, let me just sort of get to the thing of the specific, different standards, different areas. We looked at that, and what we proposed as a solution was to base it on pole height and setback distance. Because in the areas, in the newer parts of the county where you've had underground subdivisions, you don't have wooden utility poles. In those areas, you either have the taller light poles, which tend to go on wider roads, and you have the shorter light poles, which you can kind of, if you want to zoom in on one of those, you can kind of see where the green are and where the orange are. So what we tried to do with that specifically is to come up with something in which, one of the things I'll say, I was not a person who worked a lot in zoning 2 years ago. And I agree with you that it is a very complicated, and I seemingly have found the most complicated way to jump into learning it. But in doing this, there are some zones that when we first were looking at this, when we changed the zoning code, we didn't carry those over. My concern is that it makes it even more difficult to interpret the zoning code if we go beyond into smaller and smaller categories, because there inevitably will be something that we missed or we left behind, or we have an unintended consequence. And so what we tried to pick was, what could we pick that was uniform? And given the fact that there are standards for DOT installed traffic lights, street lights rather, right? That's why we picked the one there. In terms of the issue of some neighborhoods not getting service, that does tend to run afoul of what Jeff was talking about earlier in the FCC standards for what is a denial of service. To be on the safe side and put us in the best effective legal footing, that we can say that we are not picking winners and losers between different types of technology. If you want to be a person who goes to your house and you don't install cable modem service to get and Wi-Fi, and instead you want to rely on using your cell phone as your hotspot for your house, or you want to install and have a wireless plan entirely in doing that, we're not precluding that as a choice that you're making.
It's a really interesting point.
If the choice is available, which gets to the other issue, which is that the wireless companies are not today compelled to provide universal service.
That is correct. However, there are options similar to something that where we're talking about use of our county-owned streetlights. There are ways that you could look at structuring those agreements so that if you want to use the more attractive areas, there can be obligations that go in there for using the areas that have less service. The county has also created checkspeedmontgomery.com, which is a crowdsourcing ability for people to basically test the speed of their wireless service and their wireline service, so that we can also kind of assess where do you have a lot of use, where do you have places where people have limited options.
May I comment on this issue? Because it's, are you,
I'll yield, sure.
okay. Well, first of all, I do think, I mean, you've highlighted the issue, which is that there are many neighborhoods where people have more concerns, and mostly those neighborhoods are places that don't have existing utility poles. And what we have before us.
And to clarify, if I may,
Yeah.
and with larger lots,
Right.
it may be feasible to have a 60-foot setback,
But
where
we-
the
well,
where
and
the
we have
development is
allowed
not as
for-
dense.
Well, I think our approach in the CTA, which I think is a good approach, is to say that those locations will have conditional use. So at that point, the county has the ability. Correct,
New
because it's a
structure
new
is subject to
structure.
conditional use.
So that's a good way to resolve that. But I wanted to pick up on something that Mitzi mentioned, which gets to an underlying issue, which is that if you take a step back and look at what's going on, this is broadband speed wireless in the future. It does have fiber underneath it. Crown Castle built a fiber network, and then they put out antennas. Today in the county, we're very fortunate to have two fiber, companies, three, I guess, serving the county. So we have a choice of fiber. Most communities don't even have that. But when you look down the road, what we're looking at is more, essentially. You're having T-Mobile wants to come in and serve broadband speed wireless. AT&T wants to come in and serve broadband speed wireless. So we will now have the choice, hopefully, of multiple providers in a more competitive marketplace, and ideally we'll have better service and lower cost as a result. And if we were to say, well, not in this neighborhood, essentially what you're doing is you are pushing those residents to have fewer choices, more reliance upon existing incumbent providers perhaps, and they may not have the advantages of other residents to choose better service and lower costs. So I think we got to be careful about that implication as well, but I think it's overall good news that there are more companies that want to provide service, and we'll have better service and lower cost as a result. Theoretically, that's the way that markets typically work. But I think that this underlying issue of, where it is most challenging, saying that's going to be conditional use. That won't be, you can't just do that. I think is a nice way to resolve that. And now with the amendment we've just discussed, we've removed the lower limit of how close those can be to the home from 10 feet to 30 feet. We've raised it to 30 feet. So 30 feet is the closest it can be. That's also, I think, a nice refinement. So
How do we know that may I? How do we know that will work? I mean, I can imagine I'm going to get lobbied this afternoon by some of the distinguished people in the audience from the transmission companies who will say there are some cases where we got to have 10 feet. How do we know that we've just eliminated 10 feet and that's okay?
Well, what we did is by looking at the mapping data, what we were specifically looking for were there large neighborhoods where they have a lot of dark brown, and probably Clarksburg would be the place to look, because that's where you've had things that are closer. So we looked at that. The other thing that I would press upon is that so here, Okay, so the different shapes are showing that those poles are owned by, they're not the counties. They have different shapes depending on who owns them.
This is up county, so it's,
So if you go up, they're probably Allegheny or whatever Allegheny became. It's on the legend. You gotta scroll up on that bar just to the, there you go. So those are Allegheny, are the triangles that are up there, and then the county streetlights are the round circles. So in this area, what you can see is there are very few things showing that are the dark, I'll just point this out. So this is the dark brown, right? This one is showing that it is more than 10 feet, but less than 30 feet. This is closer than 10 feet. These ones are at least 30 feet. The red circles show you that it was at least 30 feet, but it's less than 60 feet. So you see here, these ones should be at least 60 feet back from the house. They are under 22 feet because they're conditional use. These ones are taller than 22 feet, and they are at least 30 feet back, and they're at least 60 feet back because you're not seeing the pink circles. We're going to check on that to make sure. But the other thing that we're hoping to do is that at least initially, you could deploy more things on these taller poles. And you're right to say that the residential is going to be sort of the last place that has the most use. It's going to be when you get 50 people walk out of the metro at the same time, or they all walk into the movie theater, they all walk into the Whole Foods at the same time. You're going to have a lot of concentrated demand at that period of time. But what you're also doing is you're giving business certainty, so that I'm trying to design this network so that when I fill in, I want to try to pick places where I don't have to go and get conditional use. I can use these existing structures. So the other reason for adopting it now is in the planning that's going to go forward, and as that technology evolves, if people are looking to see what is the most streamlined way that I can use the county, and the streamlined way to do that is to comply with the reasonable height and setback limits that the county has required.
So you've mapped the county and you believe that service can still be provided. It's not a prohibition of service if we say 30 feet is the closest you can get through conditional use. And so you're comfortable with that, and I defer to your evaluation there. Makes sense to me. So I think we ought to move this forward. I think we ought to move it out of committee.
Well, we're not done. We're
Okay,
not
sorry, I thought we were.
done. Almost, but I'd like to think. Okay, we've recommending an adjustment to the 60-foot point. And then it could be, the applicant could argue for reduction to 30 feet.
right.
We've talked about the increase in the bulk for equipment. I think that was to
Yeah, we
allow
really talked about
for
that.
possible inclusion of co-locations. Then we have some amendments.
The amendments are.
Are they technical?
They're really
kinda
pretty technical. The first two are absolutely technical. The last one is an additional requirement of communication between the Tower Committee and DPS, so that DPS has everything that
They're in the
Tower
loop.
Committee has.
That will allow.
So I think those are really no-brainer changes. I will say one thing about the Tower Committee for 2 seconds. It's not an approval body. It recommends to either DPS or the hearing examiner whether they think it should proceed.
So the deciding parties here are the hearing examiner, A, or DPS?
DPS.
If it's a permitted use.
Right. If it's a limited use, it goes through DPS. DPS makes the determinations that it meets all the condition. If it goes
Doesn't
to,
go through the Tower Committee.
Well, it goes, so it
goes to
does
the
not,
town-
the deciding, what we're talking about is who makes the final decision.
right, the Tower Committee looks at looks at some aspects of need for the facility, looks at whether there are other co-location opportunities so that it
So
makes.
for every application, it goes through the Tower Committee.
Yes.
But in the case of a limited use, DPS allows it by right with appropriate enforcement and policing, we hope. And in the case of a conditional use, the hearing examiner has to approve it. Got it.
And then it goes to DPS.
Right,
They should do.
ultimately, it'll need a.
Based upon whatever the hearing examiner rules,
Okay.
they implement it.
So now we asked you to draft something having to do with, I think it was DPS. I didn't write it down. We've covered so much ground since then.
You asked for something that makes sure DPS has enforcement authority, something that does, requires what we can require with double poles. Again, I think those might both be post-zoning. I mean, it really,
I actually think that we can come up with something very workable.
Some language that,
Okay.
that we can use.
Okay.
Okay.
And I have some thoughts, and
Okay, so let me ask you to put your heads together on that. I didn't think we'd make this much progress. Mr. Leventhal, there was something you wanted to say a while back, and I wanted to get us through the packet. So are there other points you wanted to add?
Well, you were saying that you think it's a shame that we're dealing with this in such a hastened timeframe, and I can't predict right now, given the complexity of this and the emotions that are out there in the community, whether the council will in fact act on this. I
that's-
think that it doesn't go away. I mean, the Fed committee's done its work, and you could have a Fed committee recommendation, and the new council could convene in January, February. And I'm not saying that's what's going to happen, Joy, but I don't know what's going to happen here. This is a hard issue for elected officials to get their minds around. And whatever work we do in this committee isn't lost. If there's a Fed committee recommendation, it doesn't evaporate. The next council may take it up. We either will or we won't get to this by the end of October. I can't predict where the votes are on this. So this work is not wasted, regardless of whether it ends up garnering votes in the full council. What I can guarantee is that whoever is answering these questions, whether it's Ms. Herrera or Ms. Jones, had better be prepared to answer a whole lot of other questions we haven't even anticipated here, and a whole lot of efforts by council members to propose new approaches and compromises. And that'll take time to work through, and we either will or we won't get it done by October 31st.
Just as a matter of legal timing here, if this is not acted on by council, it has to be reintroduced, a new
They'll have to
public
start all
hearing
over.
for the next council. The soonest you could act on it is something like February of next year after the General Assembly is.
So legislation expires, but legislation does not expire, but ZTAs do?
That's correct.
Thank you. Okay, that's helpful.
May I comment? Appreciate your point that other council members are not as up to speed as we have had to become in order to work on this at committee. This was first introduced more than 2 years ago, and we have worked this thing over, up, and down, every which way. And, I can't think of actually another provision that we've discussed where we have spent more time, more effort, and heard from the community more. We've had 3 public hearings on this topic, 4 public hearings on this topic, town halls. We've just had a tremendous amount of engagement, and I think it would be unfortunate to essentially, require the next council to go through all that over again. But there's urgent reasons to act now, which is the FCC. We want to take the FCC to court. We can't do that without our own ordinance. We're not going to be in a strong place without our own ordinance. We want to fight off the industry's attempts to take away our control in the state legislature. We can't do that without our own ordinance. So we really do need to act now, and I hope that we will. But we have some education with council members.
Ms. Nurmi?
Thanks. I just wanted to go back to what Mr. Leventhal was saying about the wireless and do you need it, where you need it. And I would urge you to go back and reread Earl Stoddard's testimony, who is our head of our emergency.
No, that's right.
He said, and I think a number of constituents and residents testified to the fact that they couldn't get service in their neighborhood when they wanted to call 911. Wherever you are in the county, you need to be able to call 911 and get help. Earl Stoddard also said that in the coming years, they're expecting that when an ambulance comes to your house to render medical emergency assistance to you, they may be communicating wirelessly with the hospital, with doctors, with the health professionals to actually treat you there in your home and on your way to the hospital to the greatest extent possible. You will not be able to do that without wireless. The ambulances do not come with a cable installed. So I think I would urge you to go back and reread his testimony. I thought it was very compelling. And again, to some of these residents in areas of the county like Burtonsville and so on and so forth, where the
Yeah.
service is spotty.
That was really something that I don't think any of us had fully appreciated, the public safety elements of that, and what our public safety obligation to the community is. It's, some might say that's the overriding issue. So, in any event, okay, I think we're done.
Yeah.
Amazing.
So I'll redraft per your
You
instruction.
can add draft that, yes, draft this with this, the amendment we've agreed to, and we'll see some additional language that can come to the full council. But I
Okay.
think the Fed committee's done.
Okay.
Rio?
Okay, but I do think we need to really, you can't say often enough that for those neighborhoods where utilities are undergrounded, it's easy to lose track of this, and we need to keep repeating this. It's all still conditional use.
Yeah.
If it's a new structure, there's input, there's a public hearing, there's a decision by the hearing examiner. We are not overriding neighborhood wishes. We are working with those neighborhoods, because in those neighborhoods, it'll still be conditional use. That, I guess I knew that, but it's vividly clear in mind now, and that may be the most important point of all.
I'm not sure if people had fully understood that.
Big compromise.
3-0 with amendment.
3-0 with amendments, thank you.